There's a new bill towards the making of a law to reform legal education in Ghana. I mentioned to you last week that the current situation had been that in 2019, the students who sat the exams to qualify to go to the law school, to be qualified to become lawyers, about 90% or more failed the exams. In 2021, over 70% failed the exams. In 2023, over 60% failed the exams. It doesn't matter that those who sat the exams, some of them were first-class students from their law faculties where they had done the LLB. But to move on further became a problem. There are many who have sat the exam once, twice, 3 times. Some have given up, some are just fed up. It's brought a lot of stress on people. It brought mental situations. Some have had to look for money they don't have to travel to other countries to get that education, to come back to Ghana to do a brief sort of a touch-up that we do for them so they can practice law in Ghana. It looks like all of that frustration will end with this new regime. But is it the best way forward? That's the question we are seeking to answer. Don't go anywhere. We'll be right back.
For the good work that has been done on this bill and for all the commendations. I was very happy that my colleague, the Honorable Tony Imia, said that this was a wonderful opportunity coming from the opposition. I thought that was very reassuring. And this is because the bill, as the Honorable Majority Leader has pointed out, it accords with the letter and spirit of the Constitution in Article 25 to create equality of opportunity for every one of our citizens desirous of becoming lawyers. The Honorable Majority Leader has described how strenuous it was for people to become lawyers in the past. But though it was a very strenuous system, it also guaranteed automatic entry to the law school if you were qualified enough to go through the LLB program. What this bill does is to clear the bottleneck, which is the monopoly of the Ghana School of Law, and also the so-called entrance exam that made it virtually impossible for even students who graduated with first class from very reputable universities to get into the Ghana School of Law. So, Mr. Speaker, the innovations introduced by this bill are very clear for everyone to see. We are introducing an accreditation program that will make sure that it is not every mushroom LLB school that will produce lawyers who will go on to write the bar exam. There will be accreditation and quality control to ensure that if there is a university producing LLB candidates, those candidates would have gone through a training that is either equivalent to or better than what I went through or what the Majority Leader went through before becoming lawyers. Mr. Speaker, we are also introducing the national bar exam, so that those who go through the law practice training course at the universities, the accredited universities, can all write the national bar exam, which will be a standardized exam, that will be administered by the Council for Legal Education and its bar examination committee.
The many law students, those who have qualified from law faculties, have done their first, second, third world wars, and are giving up their attempts to eventually be able to do the practical training and to become lawyers, who were disappointed that last week we were unable to treat this subject. I know you are tuned in again, and just get ready for the very best. I know the reason I'm saying that. We have Kweku Ansansari, former director of the Ghana School of Law, with us here in the studio. He brings that, institutional knowledge, practical experience, in addition to his many, many years of practice at the bar, to help us understand this legal education reform bill better. Thank you very much for making time to join us this afternoon. Right. So, when we entered the law school, it didn't take long and he exited. And then Major Sapong came in and subsequently other directors came in. Also here in the studio is a teacher of the law who was with us last week, Gertrude Amoko Ama. She teaches the law at the UPSA Law School, and she's senior associate, also the Power Law and associate. Joining us via Zoom, our very good friend in Siani is Daniel Kurang, partner, Adum Legal Consults, and author of several legal texts, over a dozen of them so far, particularly in criminal law. So, ladies and gentlemen, good afternoon and welcome to the law. And let me inform you that there are many, 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 many law students who are looking to enter the law school, who are tuned in today, and they want direct assurances about their future. So, you listen to the Attorney General. I'm beginning with Gertrude. Sure. You listen to the Attorney General.
Yes, I did.
There are people who listen to him and say, how did that happen? That students who got first class could not qualify to the Ghana School of Law. What kind of system is this?
Good afternoon, and thank you so much, Samson. It's a pleasure to be here again. That premise I find to be a very interesting one, and I think that it's not a very good starting point for the discussion. Because you see, the fact that you may have excelled at the Bachelor of Law stage, really, it cannot be a guarantee that when you have to take an external examination, it's guaranteed that you would pass. It's the same way that, for example, we may have students coming from the law faculties who may have made a pass or a third class, but are able to pass.
The natural expectation is that the law school is looking for the brightest, the best and brightest from the law faculties. And somebody makes a first class from the law faculty and getting into the law school, they are stuck.
Those are very subjective concepts. Remember that the making of the Bachelor of Laws degree is something that takes a 4-year period or a 3-year period.
Right.
Previously 2 years for some people. here you have all that 4, 3, or 2 years of experience sitting down for a 2-hour entrance examination, right? In 2 hours, you need to test or you need to prove your ability to enter into that institution. So I believe that we should not limit the discussion to the fact that some first class, I've experienced that. Some of my most painful memories or experiences was knowing that my first class students or other similar bright students didn't make it within that 2-hour examination, but subsequently, many of them tried and then they made it. So really, I believe that we don't have to start the conversation from there because it's actually
So does that not suggest that there has been something wrong with the existing system?
In terms of something being wrong with the existing system, yes. There has to some extent, and these calls for reform have been long made.
Right.
Now, in my opinion, the reforms that are being proposed, or in actual fact, within the next few days, it's likely that the bill will be passed and then will be the system that we'll have to run with. For me, we always need to, or in my personal opinion, we can look at these reforms from 3 overarching perspectives. Okay?
Hold on with that.
Right.
Hold on with that. So I want to listen to you guys first before I come to Mr. Ansari. Now, Daniel, when I entered law school, I didn't have to write any exam. We just passed our LLB and straightforward, we packed bag and baggage and came to the law school. And seeing students who have done the LLB, you know, just some of them are just gnashing their teeth. It got to a point where we had in excess of 2,000 or so, you know, sitting at home and not getting access to enter the law school. You have also had the privilege of teaching students. Do you find that, again, a situation that compels some to look for money they didn't have to go elsewhere to get the law school training to return to Ghana? First of all, do you think there has been something wrong with that system?
Thank you very much, Samson, and good afternoon to your cherished viewers, as well as to the other panelists. In fact, the introduction of the entrance exams to the Ghana School of Law was not one that was done out of convenience. It was done out of great inconvenience to ensure that we would have a system to exclude people and include others. So I have said that it is an exclusionary exam that seeks to disqualify people just so we will have justification. Now, when you look at the way the entrance exam was introduced, that was when, or at the time when, the number of applicants to the Ghana School of Law began to exceed the logistical capacity of the Ghana School of Law. And so when the Ghana School of Law realized that they were not capable of accommodating or, admitting all the increasing number of students, they had to introduce the entrance exam system. And so, first of all, I want us to understand that it was not a measure of trying to, distinguish the best from the very worst. No, it was a measure or a strategy to ensure that the limited space at the Ghana School of Law will be kept the same way, but nobody will be blamed for the mess. And so we don't have to say that anybody who fails the entrance exams is a bad at all. That is why you began by saying that you could have some first-class students from the faculties not making it. I agree entirely with Gertrude that having a first class is not necessarily because somebody is the best student. Exam can favor even the very weak at any point in time. But it presents a very bizarre situation to realize that somebody with a first class from his or her faculty is not able to make it at the entrance exam. And this is, so because the entrance exam is conducted in 6 of the many courses that are taken or learned at the faculty level. So it is quite strange that somebody who has gone through a system of education at the degree level, he has, got to be instructed, he has learned, he has passed all his exams. He goes to take exam in the same courses, and he is told that he has failed. For me, I have not condemned those who fail. I have always told them that you have been legally excluded from the admission list.
I'm sure that Mr. Ansari would disagree with your prognosis or your diagnosis, because I've heard him give the history, and that takes us back to the very first batch of students that were admitted into the law school. And it was not because there was a logistical problem, and that is why they needed to, as it were, winnow and exclude students. And when we were about to leave the law school, then they began to introduce satellite campuses to increase the numbers. I doubt at the time too that when they were finding ways to sieve the numbers, it was not because the capacity did not exist. Yes, Mr. Ansari, we have known, and you have told that history over and again. Was the exam for the purpose of simply excluding people, however qualified, because there was no capacity infrastructurally?
Thank you very much, and thanks to viewers. I don't think that the objective of the exam was to exclude anyone. It was a question of infrastructure problem. Now, to put the discussion in a historical perspective, the entrance exam was introduced in November 1958. I've said this time and time again, 1958. And in 1958, the applicants numbered 628. And the first director of the law school, Professor J.H.A. Lang, had wished to admit 50. And Nkrumah said no, that he should allow all of them, should admit all 628 students, and that the final exam would determine who will become lawyers. And that's exactly what he did. And therefore, in June 1963, when the first batch of Ghanaian lawyers, 9 of them were called to the bar, it was out of a number of 628, some of whom had fallen by the wayside. And therefore, the final year exam was taken by 32 students, and only 9 were called to the bar. So that has been the history from time to time. And then, after the overthrow of Nkrumah, the entrance exam was abolished, and then became free for all. So you enter, you do the BA, LLB law, you finished 3 years, 4 years, you enter the Ghana School of Law. Of
course, there was only one law faculty.
Only one law faculty, and that was in June 1963, when the teaching program of the law school was transferred from Makola to the University of Ghana. So when the teaching program was set up, the University of Ghana, what they did, what the faculty, it was then the Department of Law, what they did was to make sure that the students it admitted would go through the mill, as it were, combine the liberal arts courses with law courses, and then ultimately get called to the bar. So when I entered Legon in 74, we had the part 1 as 4th year. Yes, part
I was not born.
Was 4th year, and part 2 the 5th year. Right. So we would say 1st year FUE, 2nd year, 3rd year, 4th year Makola, 5th year Makola. Then in 1977, Legon established the external degree division at the Workers' College to prepare persons who wish to become lawyers to do a 9-month program. And then that will qualify them for admission to the law school. That was the QCL, the qualifying certificate in law. That was introduced in 1977. So between 77 and 92, when we decoupled the academic component from the professional one, Legon was responsible for both. In 1992, the law school decided that it would administer the QCL because that was preparatory to the actual professional law course. And therefore, we removed the program from Legon back to the law school. Now, why the entrance exams was reintroduced, I believe, in 2012, was because of limitation of space. There were, time, space, resources, everything, was inadequate.
So Daniel is right.
Yes. So the actual reason for the entrance exam was not so much to exclude brilliant first-class students, I'll come to that, but there was simply inadequate space. Now, in 2002, under my directorship, when I realized that one day there would be a problem, I set up the law faculty in Kumasi to break the monopoly of Legon. Because until 2002, law was studied at the University of Ghana. And therefore, if you wish to become a lawyer, you necessarily had to go to...
I remember the criticism at Professor Andam that
yes.
This is a technocratic, institution, yes. And you are bringing in law and yes.
So it was actually Andam who approved the General Legal Council, then under the chairmanship of Chief Justice Kwesi Redu.
Okay.
And when the General Legal Council endorsed the idea, we set up a committee, and that resulted in the establishment of the law faculty in Kumasi. And then later, in 2008, while I was on leave, former President Kufuor suggested that we should set up a satellite law school in Kumasi, which led to the establishment of the Kumasi campus of the Ghana School of Law, and then to University of Ghana, then to the Bankers Institute and all that. So government have been trying from time to time to ensure that as many as possible will be able to enter the law school, but the resources are not there. As to why first-class students may not necessarily make it, the problem does not lie with the examination.
Right.
The problem lies with the individual. If you are a first-class student, you have no business going to court. Your business is to teach. Teach. And I always tell my students, first-class students will find it difficult to enter the law school because first-class students will theorize. You ask a simple question, what is law? They write 25 pages. The second lower student or third class or ordinary pass, what is law? We just give you, what is law. So if Tokonu says the law is the law, they will give you the law is the law. And, you see, yes.
Okay, yeah. An interesting, angle to, begin this discussion with, but we're doing this under 1 hour. So let's begin straight to see what is in the new, the reforms that are being sought to be done. If you have a staggering, say, out of 5,000 students who are sitting law entrance examination and only 1,441 pass or make the cut, and that leaves over 3,599 students to try again the next year. That is a problem for this country. Is this, Mr. Ansari, is this the major purpose of the liberalization that the new reform is bringing?
Thank you. I think the new reforms has some political, twist here and there. This ought to have been done much, longer, many, many years ago. But as it were, we hadn't found a political will, to translate our dreams into reality. And I think Ayini, has done exceedingly well in pushing this reform forward. When I got your invitation, I said, was it a law school reform bill? It's not a law school reform bill at all. It's legal education. But then if you scrutinize the reform bill, clause by clause, it is actually reform of the Ghana School of Law. When you look at the object, clause by clause, you look at other things. But you see, first of all, it is a misnomer to think that the law school was established by law. The law school, until now, has not been established by law. So what the General Legal Council did in 1959 was to look for space where intending lawyers would be taught law. In that space, they found, the General Legal Council building. But then Kwame Nkrumah had, the basic idea of establishing a law school, but the law to back the establishment has not been passed to date. So this is the first time that we are going to have a law school properly so called. Now, in terms of the reform, you see that, one, if the bill is passed, it will enhance the profile of the law school. So for the first time, we have, a law school legally established. Secondly, the bill mentions the Council for Legal Education, not the General Legal Council.
Replacing the General Legal Council.
No, not to replace. It is decoupling the functions of the General Legal Council, because to date, the General Legal Council administers and superintends legal education and at the same time regulates professional lawyers. Now, a law school is a place where intending professional practitioners of the law will be trained. And then law graduates will be trained at the faculty level. So the route to becoming a lawyer has always remained twofold. The faculty, then the law school. Now, what the General Legal Council has done over the years is to seek to regulate both. But that amounts to interference with academic freedom, because each of the public universities is established by an act of parliament, and each of them has its do's and don'ts. And the General Legal Council dovetails into what the academic phases are doing, and that causes problems. So now this reform seeks to separate the functions. So the Legal Council,
the regulatory and the professional,
and practice. Then General Legal Council, you look after the professional aspects of the lawyer, discipline, that set exam. So you see that clause 72 of the bill, for instance, deals with the establishment of the National Bar Examination Committee, and that is going to be responsible for the examination of intending lawyers. So the faculties will continue to train law graduates who will then now enact a 1 year, that is 9 months, the legal practice training program. And when they finish, they are issued with the legal practice training certificate, which will entitle them to go and write the entrance exam. And when the bar exam, and when they pass, they are enrolled by the General Legal Council. So the General Legal Council continues to, call successful students to the Ghana Bar. And it will also continue to run the other programs for lawyers from the Commonwealth.
Right. So, Gertrude, is it not somewhat an attempt to delay what one would potentially have faced with the entrance exam, so that with the entrance exam, you may not have qualified, and therefore you don't get the opportunity of going to the law school.
Oh, yeah.
But now you get your LLB, and you have the potential to automatically transform into the practical training that you are supposed to get from the university, where you got your, license, you got your LLB certificate. Then when you are done and you are giving your training certificate, you are now going to sit for the bar exams, the national bar exams, which means at the bar exams, if you are not successful, you may sit back. I don't know how you.
But at least you would have taken the professional component in addition to. Before that, listening to Mr. Ansasar here, I don't know about his comments on the first class students meant for the classroom. I don't know how to feel at this point. I wasn't a first class student. I almost came close to it, but it was a very interesting point. But I'm sure we'll get the chance to discuss that more. But really, listening to the historical accounts.
There is that not a natural graduation? At the universities, when first-class students are produced, they naturally go through TA system.
We find a way of that.
They get the opportunity from the university to go and do their masters, do their
That's what I'm saying. It's an interesting point.
How many first-class law students who have graduated into professorial status, how many of them do practice? How many professors of law do you see or find?
Senior, it's a very interesting point. I think we need to conduct some actual empirical research to establish that trend. But I think to a large extent, you are right. But really, listening to the historical account, very useful, I must say. It tells us that, look, these reforms are not entirely new.
No.
They are not entirely new at all. So for, some who make it look as if this is the first time many of these things, the decoupling is going to be done, blah, 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 it appears that may not necessarily be the case. But coming straight to
But it is significant.
Very significant, and in a more, how do I put it, in a more institutionalized manner.
Right.
It has been institutionalized in a much better form.
Right.
Prior to the preparation of this bill, in those times when the advocacy, the controversy was very rife as to why we are not allowing, all those who have completed the LLBs to progress naturally to do the professional component. One of the issues that came up is exactly what you're asking. Is this not a way of delaying, as it were, the qualification? Because it's either we are doing that winnowing at the entry route or at the exit route, which is better. But I think that the discussion has to be expanded much more than that. What, in my opinion, this law is seeking to do is that regardless of where you fall, at least by the time that you would have obtained the Bachelor of Law certificate, you are given the opportunity to immediately, if you want, go ahead and also receive the professional education. And then once you have received that as well, it becomes incumbent upon you to now pass the national bar exams. So, well, to some extent, it may look as if it's a matter of delaying the qualification, but I don't think that is necessarily the case. At least you would have had the benefit of a holistic legal education, and then you now have to prove yourself by passing that examination. Right. So I don't think that we should limit it to whether...
But the decentralization where the universities that are already providing the LLB training will now be accredited to do the professional training as well is something that you endorse?
Yes, to a large extent, I do. Because we've heard Mr. Ansasar a number of times on some of the benefits of, the decoupling of that system. My only concern, really, and you did mention accreditation, the law makes it clear that there's going to be a rigorous process of accreditation such that only well-resourced and qualified law faculties are able to administer the professional components.
At the beginning, they'll get the provisional, subsequently
before they get the final. Exactly.
And then there will be I think in
periodic
each year,
yes,
there'll be twice
yes,
a process of ensuring that you
exactly we are
have
complying
right.
with the conditions of that license. Now, I think that, and really at the beginning, I wanted to make a certain point about what I believe should be the overarching objectives of any legal reform that we are seeking to make. So, for me, based on the little that I've seen over the years in the classroom and even outside of the classroom, first of all, I believe that access is important, but access ought to come with the requisite standards. So it is fine for us to, have a kind of system that allows all LLB graduates to immediately take the professional component immediately after they obtain the LLB certificates. But we need to ensure that, first of all, the universities that are providing the professional, they are well resourced and they are actually able to provide this in a manner that ensures satisfaction to the students themselves. Secondly, I also believe in reform that, as it were, ensures that for us as a people, as Ghanaians, our conception of legal education and, in fact, legal training, legal practice is changed. So this understanding that, this belief that the lawyer is only the person who goes to court in the morning and comes back in the afternoon and I think that we need the kind of reform that changes our perception about that, okay? So there has to be alternative practice areas which that reform will be promoting. Now, thirdly, reform that also provides fit-for-purpose legal education, which is consistent with emerging trends all over the world. Nowadays, many of the lawyers that we produce in Ghana, they don't only practice or they don't only provide their services to clients that are based in Ghana. Yeah. We have lawyers that are doing transactional work for clients all over the world. So it's important that even in the provision of that legal education and training, the faculties are employing innovative teaching methods that ensures that the kind of legal education that we are getting is fit for purpose. So really,
very important
for me, that is how I like to conceptualize this whole. Good question.
Do you see these points or factors you raise being catered for by this education reform bill?
Now, my review of the bill gives me the impression that
quality control and all of that.
For me, my review of the bill gives me the impression that the focus appears to be on the point one, which is assuring or ensuring that there's access to legal education. And in fact, when we started the program, you played the remarks of the Honorable Attorney General and Minister for Justice, who was saying that one of the major objectives of the bill is to clear the bottlenecks. So it looks as if the focus to a large extent has been on allowing that access or clearing that bottleneck, but it cannot just be about that.
No, but it certainly is more than that.
It certainly is more about that. And the bill to a large extent goes ahead to make provisions to ensure the quality controls as well.
Great.
But on my points 2 and 3, on points about ensuring that we have legal education which is fit for purpose and the kind of legal education that changes our conception of legal practice as a people, I think that to a large extent the bill falls short of those objectives that I have set for myself.
So yes, Daniel, from where you sit, what do you see to be the strengths and the weaknesses of this bill?
I consider the bill to promise so much, both to the aspiring lawyers and the Ghanaian society generally.
Yeah, I know students in various law faculties who are just so excited that they don't have to go through all the trouble anymore.
Yes, I think it calls for celebration, not because it is going to make access very easy and cheap, but because it is going to solve a practical problem. You see, Gertrude mentioned that the bill seeks to emphasize the access, increased access. I think it is one of the very spoken, very loud bottlenecks that the current system has. And so in every discussion or conversation, that ought to be highlighted, and I think in the first place, because to have a number of about 6,000 people sitting an exam and expecting that only about 1,000 or less will be admitted is quite a problem. And so if this...
particularly in a country particularly in a country where we know that the lawyering is very low. One of my favorite Supreme Court justices of the United States, Justice Antonin Scalia, said that the U.S. is a better country, or it is what it is, because it has many lawyers.
I agree with him.
Yes, our AGs have been looking for lawyers to man the AG's department. There are some regions, there's only one person. How do they man the AG's department?
To add to what you are saying, Samson, I have always believed that, and have advocated that, prosecution by police officers ought to be reconsidered. And if we can do that, it means we need many more lawyers to join so that we have some of them to be practicing at the AG's department as prosecutors. And so the number of lawyers in Ghana, I think, is very low. And so we should not fear that we are opening the floodgate for so many people to become lawyers.
All right.
So one of the key strengths of the bill is the increased access. And the second one I will mention is what Professor Ansasari highlighted, which is the decoupling of the two important roles of the General Legal Counsel, which is regulation of the profession and regulation of the legal education and training. I have been a lawyer for some time now, and I'm aware that the General Legal Counsel focuses so much on regulating the conduct of lawyers, ensuring professional standards, but the council does very little in terms of regulating legal education from the beginning to the end. Maybe apart from accreditation and other few matters, you don't see a comprehensive, regulation of the legal education and training. But I think that we cannot ignore the training of lawyers and focus more on the regulation of the lawyers when they have become.
Right.
And so one of the strengths is the decoupling and then ensuring that there is a comprehensive regime of regulation. Now, the bill also talks about clinical legal education.
Yes.
And for me, this is very fundamental. When I went to the Ghana School of Law, one of my disappointments was that the learning and teaching methods at the faculties are not different from what we do at the Ghana School of Law. It is the same chew and pour. It is the same theoretical approach to learning. It is the same doctrinal approach to learning. I mean, you don't see any clinical aspect where we give the students, practical approaches to the law. So conveyancing, the law of conveyancing ought not to be a theory. Criminal procedure ought not to be theory. Civil procedure ought not to be theory. But when you go to the Ghana School of Law, what you see is that the same way we learn contract law is the same way we learn criminal procedure at the Ghana School of Law. You hardly see practical aspects. So my humble view and suggestion is that once the bill emphasizes clinical legal education, the regulatory body to be established has to put in place, a very robust and effective system to ensure that we don't go to the Ghana School of Law and learn by rote or learn by chew and then pour, that kind of system. So I emphasize the clinical legal education, very, very important. And the fact that we are going to have a separate institution now to deal with legal education, I believe that one of the things that will be done is to resource that institution and ensure that it is able to deliver the promise that the bill has given us.
Yeah, Daniel, we may have, as we understand, about 1 lawyer to 5,000 citizens kind of ratio in Ghana. And we may have 11,000 lawyers with 8,000 supposed to be in active practice as in May of 2025. But we are also a small country, are we not?
Something we are, but you realize that when you look at the lawyer-client ratio in Ghana, it is very disturbing. I have always said that there can never be too many lawyers in Ghana. There can never be, because our population is not too small, to say that we have about 10,000 or 8,000 lawyers, it is too many for us. No. So I believe that if there is an opportunity for more people to become lawyers, we only have to ensure that the quality and the standard is not compromised. If we are able to maintain quality standards, I believe that the more there are lawyers in Ghana, the more
let me move to
development.
Let me move to Asasari now. But you see, there's something he said that I want you to examine this process again to be sure that we are not likely to create the same problem where the first batch, over 600 students, went through the process and they went through wholesale to the end. When they got to the end, only 30 plus, registered for the exam. And then in the end, only 9 came out as lawyers.
Yes, I think that if we are able to have people who have gone through legal education from the degree level to the professional level, and they are now going to take a kind of licensure exams to obtain a license, it's a matter of proving that you have learned enough and you are well prepared and trained to become a lawyer. Over there, the difference I see between the National Bar exam and the current entrance exam is that whereas the current entrance exam seeks to admit as many as the existing capacity can accommodate, the National Bar exam to be introduced does not look at capacity. It looks at quality. If you have obtained quality training, then you pass the exam and you are given a license to go. So I believe that the students listening to us now should not think that we are doing away with exam entirely.
All right.
You would be examined at the end of the day, but for license, not as a struggle to occupy a limited space.
Thank you. Let me come to Mr. Asasari now, and someone is asking a question that Section 61 provides that law practice training, so for now we say clause, law practice training shall last for 1 academic year, commencing in September and ending in June of the following year, and shall be supervised by an accredited institution. Having regard to the demands of the program, I am of the considered view that the training may be undertaken partly before and partly after the National Bar examination, provided that it is in all cases completed prior to the call to the bar. What do you say?
Thank you. See, the philosophy behind this reform is that of learning by doing. And that is what the entire clinical legal education thing is about, learning by doing. Some of us are even suggesting that our professional law students should be given the opportunity to practice at the magistrate level.
Great.
Let them start, committing the blunders, the errors, correct them. By the time, they finish, at least they will know, the nuances of legal practice. But like my friend said, you go to the faculty, chew and pour. You enter the law school, it's chew and pour. So we do very little practical training at the law school. Now, another objective of this reform is to change all that and make sure that the intending lawyer learns, right from the four corners of the lecture hall all through. But Gertrude made a point. Say, we want to widen access to legal education, but so far we are not thinking of quality assurance. I'm aware.
Is this law, does this law not think of quality assurance?
It is there, but you see...
Is the implementation you are concerned?
Having, the thing on paper is not the same as in practice. So our culture here is to commercialize anything, everything. If care is not taken, we are going to commercialize, the 1 year legal practice training program. Many faculties are going to admit many more for money, So one of the things that I believe should be done is to strengthen quality assurance. Another is to improve the conditions of service of the lecturers in the public universities.
Thank you, Senior.
You see, if we don't do that, and
speaking for her.
Yes, thank you.
Let them teach. You pay a professor of law about 11,000 cedis, and then his student who goes to parastatal is taking about 70,000. And the whole thing is so off-putting, it demoralizes them. Let us create the enabling condition that will attract, the likes of Gertrude and others to enter the teaching profession, so that they make the teaching profession their area of practice and not looking, to go and, find 10 CDs, by the wayside.
But the National Bar Exam is supposed to sieve that kind of thing. You are talking about something, and I'm thinking about it now. The internship program, which is supposed to immerse the students into the practical, stuff. You have a suspicion we may lose that quality?
No, as for the immersion, that's fine. The clinical aspect of it is all well and good. My problem is, how many senior, well-experienced legal practitioners are going to supervise the clinicians?
Right.
We don't have enough law firms. The few that we have are already choked. And many more students are not going to get, placements. That is one.
That's a problem even in England with pupillage.
Yes,
very competitive. Yeah.
And we are not, we haven't taken any remedial measures yet. What is more, the senior law practitioners these days are not in the habit of taking on juniors. When I was, in Legon, seniors will come there and invite. Today are problems. The younger ones are disrespectful, and therefore seniors are not, enthused into, getting them onto their firms. But my recommendation to the powers that be is that the Ghana Bar Association should be allowed to determine the number of lawyers the association will want admitted every year, like the accountants do. So you don't leave it to people, institutions that intend or aim at commercializing the whole thing. The result that we are going to produce half-baked lawyers in future, and that's a risk, that the nation is going to take.
One of your concerns being raised here, and I sit in a firm, and sometimes even the pupillage, of course, pupillage, the pupils themselves will come looking for the pupillage, but the internship,
Introduction.
My firm, what we do, we interview the potential, and we then ask the law school that we have admitted these people for you to bring. And still, we end up getting numbers that we didn't even ask for. And he talks about the problem of supervision. It becomes difficult for you. Maybe you have space for a firm like mine, 6. Then you end up, you are admitting about 12, You
see, thank you, Samson. That is why, for me, in the overarching objectives that I have set for myself, I say that one of the things we can do is to broaden the scope of practice areas. Why must it only be lawyers?
Who should that be their job? We all get the training. You decide where you want to specialize.
Why does every lawyer want to intern or do pupillage in a firm? What about our district assemblies? What about hospitals? What about other public, institutions, which also require the services of lawyers?
The concerns of the clinical legal education.
Exactly. Exactly. So let us allow them to experience.
Those who are just coming in now, they are going to sit civil, civil procedure exams. Being in a law firm, they are looking to learn, go to court and learn draft processes, and say they go to district assembly and they perhaps may not get this.
Perhaps, that's like concern. You are saying. But remember that the training at that stage, or the shadowing is supposed to be done under the guidance of a qualified lawyer. Right. The fact that that particular institution may not require conveyancing, practice does not mean that you cannot learn something from that by your own. And quickly, something I just want to add quickly to the concern about the teaching and learning methods encouraging rote learning. Currently, for clinical legal education, it looks like it's been left to the faculties. Some faculties are doing it and having innovative ways of teaching the students. Others are not. So really, one of the things the law seeks to change is by making it a must for all faculties to practice. Finally, you see, for me, it looks like this law is making the law faculties an almost complete custodian of legal education, of course, under the supervision of the Council for Legal Education and Training. And that is the reason why it is imperative that our law faculties are well-resourced and, secondly, supported immensely to deliver the objectives of the reform. So really, I don't think there's a rush.
In 30 seconds, Daniel, what will be your last words? In 30 seconds. Our time is up.
Continuing from where Gertrude left it, we have to look at the quality of lecturers. One thing is that when you come to the Ghana Education Service, teachers are trained, in what they call pedagogy or something.
Yes.
That is the art of teaching. Good. But now, some of us, we are just lawyers, and we are teaching, we are lecturing by virtue of the fact that we are lawyers. But you see, it is not every good lawyer in.
That's a point that we understand. The next 20 seconds, I leave it to you. Your very last words.
We need to reorientate our minds that the courtroom practice is not the only way of professing the law.
Right.
So like Gertrude, has been hammering, we need to specialize, we need to broaden. So you may not necessarily have to go to the law school to become an advocate in the courtroom. So you can do others. Don't go to the law school. You finish your LLB, you can go to international, Lesia, that.
Unfortunately, this is all time will allow us. And there's something that Mr. Asasari said that I think that Honorable Attorney General and your people, you should listen to and find a way around it. That even small claims, we can give them the opportunity to begin to do these things in the district court and see how it pans out. Daniel Krang is partner at Adum Legal Consult and author of legal text. Gertrude Amokoama is lecturer UPSA Law School and senior associate, Owusu Dapa Law and associate. Kuku Ansasari is former director of the Ghana School of Law. He's still in the business of raising and teaching lawyers for the country. Thank you all so very much for making time to be here. Yes. Owusu Dapa is former teacher. Well, all of us, our former teacher.
That's true.
All right. Have a good afternoon, Samson.
Thank you.